Today, we're going to break down a public court document. It was filed in 2016, but it makes some incredibly serious allegations about events that supposedly happened way back in 1994. Now, our goal here isn't to prove or disprove anything. We're just going to methodically walk through exactly what this lawsuit says, piece by piece. Let's get into it. Okay, Section 1, a shocking court document. Before we even get to the allegations themselves, you have to understand the document. Who filed it, where it was filed, and when. Every one of these details really matters. So this is it. This is the actual cover page of the complaint. You can see it right there, filed on June 20th, 2016, in the Southern District of New York. This one page establishes the official record that we're going to be looking at. So who are the parties involved here? Well, the plaintiff is listed as Jane Doe, which is a pseudonym, right, used to protect her identity. And the defendants named in the filing are Donald J. Trump and Jeffrey E. Epstein. The document then lays out some of the basic facts. The case was filed in a federal court in New York, and you'll see this line, amount in controversy exceeds $75,000. That's just a standard legal thing. It's a threshold you have to meet to bring a case in this specific type of court. All right, Section 2, the core allegations. Now that we've got the framework of the lawsuit down, we can really dig into its substance, the specific and pretty graphic claims that are detailed inside the complaint. A single number is stated right at the start of the allegations, and it's a crucial one. According to the complaint, the plaintiff, Jane Doe, was 13 years old during the summer of 1994. That's when all the events she describes allegedly took place. So, the big question is, how did a 13-year-old end up in a situation like this? Well, according to the lawsuit, she was lured in. It alleges she was enticed with promises of money and a modeling career to go to these parties at a residence being used by Jeffrey Epstein. Now, paragraph 10 of the complaint gets into specific and violent allegations aimed directly at Donald Trump. It describes 4 alleged encounters and claims that the final one ended in a forcible rape, where he allegedly tied her to a bed and struck her when she resisted. The complaint then makes separate allegations against Jeffrey Epstein. Paragraph 12 alleges 2 different instances of sexual assault, with the second being a rape that it claims happened after the one involving Trump. It also claims Epstein attempted to hit her. Now, this is a really important part. Right after describing the alleged assaults, the document details threats. It states that both Trump and Epstein on separate occasions threatened Jane Doe, warning her that she and her family could be physically harmed or even killed if she ever told anyone what happened. Okay, Section 3, 2 sworn declarations. You see, the complaint wasn't filed by itself. It was actually supported by 2 critical exhibits. These are sworn declarations signed under penalty of perjury, and they were designed to back up the lawsuit's claims. So, who made these statements? The first one is from the plaintiff herself, Jane Doe. The second is from a woman using the pseudonym Tiffany Doe, and in the document, she describes herself as a witness and also a former employee of Jeffrey Epstein. In her own sworn declaration, Jane Doe repeats the allegation about the threat from Trump. And notice the wording. She says this happened immediately following this rape, connecting that threat directly to the alleged assault. And this is why that second declaration is so important. Tiffany Doe's statement is there to try and corroborate the threat. She swears, under penalty of perjury, that she personally witnessed Trump making this physical threat against the plaintiff. Jane Doe's declaration then includes an even more specific alleged threat. She claims Trump warned her not to disappear like Maria, who she describes as another minor, a 12-year-old, and that he said he could have her whole family killed. And once again, Tiffany Doe's sworn declaration appears to directly back this up. I mean, the language is almost identical. She claims to have personally witnessed Trump making this very specific threat about Maria and about the plaintiff's family. Okay, Section 4, the argument of duress. This all leads to a really critical question that the lawsuit had to tackle head-on, right? The alleged events happened in 1994, but the suit was filed in 2016. A whole section of the complaint is dedicated to explaining that delay. This is the million-dollar question that the document has to answer for the court. Why wait 22 years? Because normally, something called the statute of limitations would prevent a lawsuit like this from ever even being heard. The plaintiff's whole argument hinges on this legal concept, tolling the statute of limitations. It sounds really technical, but think of it like this. It's a legal argument to press a pause button on the deadline. usually because something was stopping a person from coming forward, like in this case, what the document calls continuous and active duress. And here's the argument in the complaint's own words. It claims that the alleged threats were so severe and so ongoing that they basically deprived plaintiff of her freedom of will to institute suit earlier, for more than 2 decades. And to really drive home the idea of continuous duress, the document adds this one last detail. It alleges that even after filing an earlier version of the suit in California, just a few months before, the plaintiff started getting new threatening phone calls. The implication is that the duress was still active. And finally, let's look at what this lawsuit was actually asking the court to do. In legal terms, this is called the prayer for relief. The demands are laid out pretty clearly. First, money, financial damages, both to compensate for suffering and to punish the defendants. Second, legal costs, payment for all the lawyers and court fees. And third, and this is very telling given that duress argument, a formal court order of protection against any more harassment. And that's where the public record leaves us. It's a fact that this lawsuit with these sworn statements was filed. It is also a fact that it was later withdrawn. And this kind of forces a fundamental question. What is the role or the weight of a public record that contains such serious sworn allegations, even if those allegations are never actually tested in a court of law?